Chapter 10. Chapter 10, the Executive Department, 390 page 397. The office of the President was debased by Ferdinand E. Marcos, who converted it into a seat of unlimited power and unbelievable corruption. In 1986, after almost 13 years of absolute and tyrannical rule, he was deposed by an outraged and indignant citizenry. He deserves the scorn of history. Even so, his oppressive regime has taught us many lessons on liberty, which were useful in the drafting of the new article on the executive department. Indeed, the main motivation of the framers in the writing of Article 7 was to prevent the recurrence of another despot like the discredited ex-dictator. Executive Power, Article 7, Section 1, reproduces the original rule in the 1935 Constitution that the executive power shall be vested in the President of the Philippines. Executive power is briefly described as the power to enforce and administer the laws, but it is actually more than this. In the exercise of this power, the President of the Philippines assumes a plenitude of authority and the corresponding awesome responsibility that make him indeed the most influential person in the land. The potentials of the executive power are tremendous for good or evil. In the hands of a Quezon or a Magsaysay, it can be an instrument for the uplift of the common man. By contrast, a Marcos or Duterte can deprave and pervert it into a dungeon of oppression. In any event, there is no question of the impact of the presidency upon the nation. The president, like him or not, is a ubiquitous and unavoidable presence because of the many capacities in which he acts as repository and discharger of the executive power. Whether as expected company or as unwelcome infusion, the president is involved in our daily existence and undeniably affects our lives and even our destinies, no matter how distant we may be from Malacanang. Qualifications. Qualifications are prescribed for public office to ensure the proper performance of powers and duties in the case of the highest office in the land. Article 7, Section 2 provides as follows. Article 7, Section 2. Section 2. No person may be elected president unless he is a natural born citizen of the Philippines, a registered voter, able to read and write at least 40 years of age on the day of the election, and a resident of the Philippines for at least 10 years immediately preceding such election. Executive Department, Section 2. No person may be elected president unless he is a natural born citizen of the Philippines, a registered voter, able to read and write, at least 40 years of age on the day of the election, and a resident of the Philippines for at least 10 years immediately preceding such election. Qualifications are exclusive. Exclusive and may not be reduced or increased by the Congress. The applicable rule of interpretation is expressio unius is exclusio alterius. Expressio unius. All constitutional officers dealing appropriately with the president are required to be a natural-born citizens of the Philippines. A natural-born citizen is one who is a citizen of the Philippines from birth without having to perform any act to acquire or perfect his Philippine citizenship. He is distinguished from the naturalized citizen who acquires his Philippine citizenship after birth by any modes allowed by law. Naturalized, natural born. As previously observed under the provisions of the Citizenship Retention and Reacquisition Act of 2003, natural-born Filipino citizens who have been or intend to be naturalized in a foreign country shall, upon taking the oath of allegiance prescribed in said law, be deemed to have reacquired or shall retain their Philippine citizenship. Upon taking said oath, those seeking elective or appointive public office in the Philippines shall meet the qualifications for holding such public office as required by the Constitution and existing laws, and at the time of the filing of the certificate of candidacy, make a personal sworn and renunciation of any and all foreign citizenship before any public officer authorized to administer an oath. It must be noted that upon taking said second oath, the citizen ceases to be a dual citizen. Registration as a voter connotes, of course, possession of the qualifications for suffrage as enumerated in Article 5, Section 1 of the Constitution. Article 5. The literacy qualification is now expressly required because it is not deemed embraced in the suffrage qualification. The present Constitution not only does not require ability to read and write, but in fact prohibits its imposition as a qualification for voting. The age qualification for the President under the 1935 Constitution was 40 years, but this was increased to 50 years by the 1973 Charter, presumably on the justification that more maturity was needed for the highest office in the land. In the land, this did not seem to jibe with the reduction of the voting age from 21 to 18, which was based on the supposed increased sense of responsibility and competence of the younger citizens. In an interesting somersault, the age requirement was brought back to 40 years in 1984 and is now retained in the present constitution. It should be noted it should be noted that this qualification should be possessed by the candidate on the day of the election for president, regardless of the time the president-elect is actually proclaimed. The residence qualification is retained at 10 years, the object obviously being to ensure close touch by the president with the country of which he is to be the highest official in familiarity with its conditions and problems, the better for him to discharge his duties effectively. Election and proclamation. The President and the Vice President are elected by direct vote of the people, unless otherwise provided by law. The regular presidential election shall be held at 6 years interval on the second Monday of May. The canvass of the election returns and the proclamation of the winners shall be conducted under Article 7, Section 4 as follows. The returns of every election for President and Vice President, duly certified by the Board of Canvassers of each province or city, shall be transmitted to the Congress, directed to the President of the Senate. Upon receipt of the certificates of canvass, the President of the Senate shall not later than 30 days after the day of the election, upon all the certificates in the presence of the Senate and the House of Representatives in joint public session, and the Congress, upon determination of the authenticity and due execution thereof, in the manner provided by law, canvass the votes. The person having the highest number of votes shall be proclaimed elected, but in case two or more shall have an equal and highest number of votes, one of them shall forthwith be chosen by the vote of a majority of all the members of both houses of the Congress voting separately. The Congress shall promulgate its rules for the canvassing of the certificates. The Supreme Court sitting en banc shall be the sole judge of all the contests relating to the election returns and qualifications of the President or Vice President and may promulgate its rules for the purpose. As the canvass is regarded merely as a ministerial function, the Congress shall not have the power to inquire into or decide questions of alleged irregularities in the conduct of the elections. These are the matters appropriate for an election contest. Now, normally, as long as the election returns are duly certified and appear to be authentic, the Congress shall have no duty but to canvass the same and to proclaim as elected the person receiving the highest number of votes. Ministerial capacity. These are matters appropriate for an election contest, normally as long as the election returns are duly certified and appear to be authentic. The Congress shall have no duty but to canvass the same and to proclaim as elected the person receiving the highest number of votes. When the Congress meets to canvass the presidential election returns, it does not need to call to a special session by the President under Article 6, Section 15, as the canvass is mandated and called by the Constitution itself. In the unlikely but not impossible event that the election results in a tie, the one to be proclaimed shall be chosen by the vote of a majority of all the members of both houses of Congress voting separately. This procedure may clearly result in the absurd situation where a majority of all the members of the House of Representatives would choose one of the candidates involved in the tie, while a majority of all the senators would choose the other, in which case the tie would clearly not be broken. Under this section, the Supreme Court sitting en banc shall be the sole judge of all contests relating to the election returns and qualifications of the President or Vice President and may promulgate its rules for the purpose. Accordingly, pursuant to this provision, the Supreme Court promulgated in 2010 its rules establishing the Presidential Electoral Tribunal or the PET, which, among others, provided for the membership consisting consisting of the members of the Supreme Court, the authority of its chairman to appoint employees and confidential employees of every member thereof, for the establishment of a separate administrative staff of the tribunal, and the provision for a seal separate and distinct from the Supreme Court, Presidential Electoral Tribunal or the PET. which among others provided for its membership, consisting of the members of the Supreme Court. Members of the Supreme Court. Authority of the chairman to appoint employees and confidential employees of every member, thereof for the establishment of a separate administrative staff of the tribunal, and the provision for a seal separate and distinct from the Supreme Court. The legality of the PET was challenged in Makalintal versus Presidential Electoral Tribunal, where the petitioner questioned, among others, the constitution of the Presidential Electoral Tribunal or the PET as an illegal and unauthorized progeny of Section 4, Article 7 of the Constitution. The petitioner further claimed that the PET exercises quasi-judicial functions. The PET as specified by the Supreme Court in Buak versus Comelec in contravention of Section 12, Article 8 of the Constitution, which provides that the members of the Supreme Court shall not be designated to any agency performing quasi-judicial or administrative functions. Citing Texon versus Commission on Elections, the Supreme Court explained that it has original jurisdiction to decide presidential and vice presidential election protests while concurrently acting as an independent electoral tribunal. In other words, the establishment of the PET simply constitutionalized what was statutory before the 1987 Constitution. The court added that the PET is not a separate and distinct entity from the Supreme Court, albeit it has functions peculiar only to the tribunal. It is obvious that the PET was constituted in implementation of Section 4, Article 7 of the Constitution, and it faithfully complies, not unlawfully defies, the constitutional directive of the adoption of a separate seal, as well as the change in the nomenclature of the Chief Justice and the Associate Justices into chairman and members of the tribunal, respectively, was designed simply to highlight the singularity and exclusivity of the tribunal's functions as a special electoral court. It further clarified that the setup embodied in the Constitution and statutes characterizes the resolution of electoral contests as essentially an exercise of judicial power. Significantly, the court added that at the higher levels, city, provincial, and regional, as well as congressional and senatorial, exclusive and original jurisdiction is lodged in the COMELEC and in the House of Representatives and Senate electoral tribunals. Were not strictly and literally speaking courts of law. Although not courts of law, they are nonetheless empowered to resolve election contests, empowered to resolve election contests. In essence, an exercise of judicial power because of the explicit constitutional empowerment found in Section 2, Paragraph 2, Article 9C for the COMELEC and Section 17, Article 6 for the Senate and Section 2, Paragraph 2, Article 9C. Exclusive original over all contests relating to election returns and qualifications of all elective regional, provincial, and city officials in appellate jurisdiction. trial courts of general jurisdiction or involving elective barangay officials decided by trial courts of limited jurisdiction. Decisions, final orders, or rulings of the Commission on Election contests involving elective municipal and barangay offices shall be final and executory and not appealable. Section Article C. Article 7. Article 6. 6. Section 17. In Defensor Santiago versus Ramos, the Supreme Court, acting as the PET, dismissed the election protest of a presidential candidate who, during the pendency of the same, had run for and was elected to the Senate, emphasizing that she campaigned for and was actually elected to and assumed said office. The court noted that having submitted herself to be voted upon, she entered into a political contract with the electorate that if elected, she would assume the office of a senator, discharge his functions, and serve her constituency as such for the term for which she was elected. The court declared that in assuming the office of senator, then the protestant has effectively abandoned or withdrawn this protest, or at the very least, in the language of Moraleja, abandoned her determination to protect and pursue the public interest involved in the matter of who is the real choice of the electorate. Such abandonment or withdrawal operates to render moot the instant protest. This ruling was affirmed in a vice presidential election contest where the Protestant ran for and won a seat in the Senate during the pendency of her aforesaid action before the term. The term of the president and the vice president is fixed by Section 4 as follows. The president and the vice president shall be elected by shall be the president and the vice president shall be elected by direct vote of the people for a term of 6 years, which shall begin at noon on the 30th day of June next following the day of the election, and shall end at noon of the same date 6 years thereafter. The president shall not be eligible for any re-election. No person who has succeeded as president and has served as much as such for more than 4 years shall be qualified for election to the same office at any time. It is expected that because the president is not eligible for re-election, he shall devote his attention during his lone term to the proper discharge of his office instead of using its perquisites to ensure his remaining therein for another term. This was the original rule in the Commonwealth Constitution, but it was amended in 1940 upon the strong advocacy of the incumbent President Manuel L. Quezon, who argued that 6 years was too long for a bad president and too short for a good president, presumably meaning himself. The amendment was adopted. In the 1971 Constitutional Convention, there was a strong sentiment to prohibit re-election of the president, possibly because of the known plans of President Marcos to run for re-election, notwithstanding that he was already disqualified under the 1935 Charter. The issue was mooted, however, when a parliamentary system was adopted and the president was reduced to a mere figurehead. When the presidential system was restored, there was no thought of limiting the term of President Marcos, who apparently planned to stay in office for life. But with his ouster in 1986, the Constitutional Commission saw fit to put a rein on presidential ambitions and tenure, and so provided for this limitation of only one presidential term. The term of the president is fixed at only 6 years, but it was extended by a few months in the case of President Aquino. Although her term began on February 25, 1986, it was provided in Article Article 18, Section 5 that the 6-year term of the incumbent president and vice president elected in the February 7, 1986 election is for purposes of synchronization of elections hereby extended to noon of June 30, 1992. The next regular election for the president and vice president was held on the second Monday of that year. The question of whether or not the president can run for another term after other persons shall have served in his former office has yet to be settled by the Supreme Court. One view is that the president can be re-elected provided this is not done immediately following his first term. Others contend that he is forever disqualified because Section 4 provides that the president shall not be eligible for any re-election. Gloria Macapagal Arroyo was succeeded President Estrada, who succeeded President Estrada on January 20, 2001, and was therefore eligible for election in her own right because she had not served more than 4 years by the end of her predecessor's term, which expired on June 30, 2004. If her unexpired term exceeded that period, she would not have been qualified for election to the same office at any time. Estrada, on the other hand, was elected president in 1998 and served only four or resigned from office after less than 3 years. This notwithstanding, he ran for president again in 2010 and almost won. In Formento versus Estrada, the petitioner sought to disqualify Estrada from participating in the 2010 presidential election on the basis of this constitutional provision which states that no president shall be eligible for any re-election. While the Supreme Court acknowledged that the novelty and complexity of the constitutional issue involved in this case present a temptation that magistrates, lawyers, legal scholars, and law students alike would find hard to resist, it nevertheless dismissed the petition, stating that considering that Estrada was actually not elected president for the second time, any discussion of his re-election will simply be hypothetical and speculative. It will serve no useful or practical purpose. It said prudence dictates that this court exercise judicial restraint where the issue before it has already been mooted by subsequent events. More importantly, the constitutional requirement of the existence of a case or an actual controversy for the proper exercise of the power of judicial review constrains us to refuse the allure of making a grand pronouncement that in the end will amount to nothing but a non-binding opinion. In Lonzanida versus Commission on Elections, the petitioner was elected 3 times as mayor but lost in an election protest and was ousted during his third term. Interpreting the three-term limit rule in the Constitution and the local government code for local officials, the Supreme Court held that he was not disqualified from running for the same position again because his third election was nullified and he did not fully serve the third term. However, this ruling is not necessarily decisive of the question as it applies to the term limits of the President and the Vice President. The Vice President, the new Constitution retains the office of the President, who shall, with the President, be elected directly by the people for the same term of 6 years. It may be removed also only through the process of impeachment. His qualifications. His qualifications are the same as those of President. The Vice President is eligible for the position of member of the Cabinet when appointed as such, does not need confirmation by the Commission on Appointments. This is intended to prevent him from becoming a mere presidential standby, a superfluous excellency, with nothing more to do than pray for a vacancy in the presidency. Nevertheless, he may not demand such appointment, nor may he, conversely, be compelled to accept it. The new provisions on the office of the Vice President are as follows. Section 3, there shall be a Vice President who shall have the same qualifications in term of office and be elected and in the same manner as the President. He may be removed from office in the same manner as the President. The Vice President may be appointed as a member of the Cabinet. Such appointment requires no confirmation. Section 4, Paragraph 2, no Vice President shall serve for more than 2 successive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of the service for the full term for which he was elected. Whenever there is a vacancy in the office of the Vice President during the term for which he was elected, the President shall nominate a Vice President from among the members of the Senate and the House of Representatives who shall assume office upon confirmation by majority vote of all the members of both houses of Congress voting separately. It is to be noted that whereas the President is not eligible for any re-election, the Vice President is allowed to serve as such for two successive terms. The question is, after an interval during which some other persons may have served as President, would he again be eligible for the same office? Section 9, which was copied from Amendment 25 of the U.S. Constitution, was applied when Vice President Arroyo replaced President Joseph Estrada and thereby vacated her former office to fill the vacancy. She nominated Senator Teofisto T. Gincona Jr., who, with the concurrence of the Congress, took the oath as the new Vice President. As in Section 4, which provides for settlement of ties in presidential elections, this provision likewise requires a separate majority vote of all the members of both houses of Congress in the confirmation of the nomination by the President of a Vice President. It would be clear that such nomination would not be considered confirmed without the concurrence of the separate votes of both houses. Presidential succession. There are two sets of rules on presidential succession. One found in Section 7 on vacancies. Section 7 on vacancies occurring before the president's term, and the other 8 on vacancies occurring afterwards. Or no, Section 7. Section 7, the President-elect and Vice President-elect shall assume office at the beginning of their terms. If the President-elect fails to qualify, the Vice President-elect shall act as President until the President-elect shall have qualified. If a President shall not have been chosen, the Vice President-elect shall act as President until a President shall have been chosen and qualified. If at the beginning of the term of the President-elect shall have died or shall have become permanently disabled, the Vice President-elect shall become President. Where no President and Vice President shall have been chosen or shall have qualified, or where both shall have died or becomes permanently disabled, the President of the Senate, or in case of his inability, the Speaker of the House of Representatives shall act as President until a President or a Vice President shall have been chosen and qualified. The Congress shall by law provide for the manner in which one who is to act as President shall be elected until a President or a Vice President shall have qualified. In case of death, permanent disability, or inability of the officials mentioned in the next preceding paragraph. In case of death, permanent disability, removal from office, or resignation of the President, the Vice President shall become President to serve the unexpired term. In case of death, permanent disability, removal from office, or resignation of both the President and the Vice President, the President of the Senate, or in case of his inability, the Speaker of the House of Representatives shall then act as President until the President or Vice President shall have been elected and qualified. The Congress shall by law provide who shall serve as President in case of death, permanent disability, or resignation of the acting President. He shall serve until the President or the Vice President shall have been elected and qualified and be subject to the same restrictions of powers and disqualifications as the acting President. The cases contemplated in the first section are: first, death or permanent disability of the President-elect, and second, failure to elect the President as per the canvass of the presidential elections has not yet been contemplated, or where for one reason or another the presidential election has not been held, and failure of the President to qualify, that is, to assume his office by taking the oath and entering into the discharge of his duties. In the first case, the Vice President-elect shall become President. In the other two cases, the Vice President-elect shall merely act as President until such time as the President shall have been chosen and qualified. The second section deals with vacancies occurring in the office of the President during the incumbency and is limited to four specified situations, to wit, death, permanent disability, removal, resignation. Death, resignation, and removal are self-explanatory. Incurable insanity is an example of permanent disability. In any of these situations, the Vice President shall become President. In Estrada versus Gloria Macapagal Arroyo, the petitioner questioned the respondent's right to succeed him as President, claiming that he had left Malacanang on January 20, 2001, only to defuse the tension building up among the demonstrators at EDSA who were demanding his resignation. He denied he had resigned and said he shall have ended but was being prevented from doing so and rejecting this pretense. Justice Renato Espuno declared in part of the court, in sum, we hold that the resignation of the petitioner cannot be doubted. It was confirmed by his leaving Malacanang. In the press release containing his final statement, he acknowledged the oath-taking of the respondent as President of the Republic, albeit with reservation about its legality. He emphasized he was leaving the palace, the seat of the presidency, for the sake of peace and in order to begin the healing process of our nation. He didn't say he was leaving the palace due to any kind of inability and that he was going to reassume the presidency as soon as the disability appears. He expressed his gratitude to the people for the opportunity to serve them. Without doubt, he was referring to the past opportunity given him to serve the people as their president. He assured that he will not shrink from any future challenge that may come ahead in the same service of our country. Petitioner's reference is to a future challenge after occupying the office of the president, which he has given up. And 5, he called on his supporters to join him in the promotion of a national spirit of reconciliation and solidarity. Certainly, the national spirit of reconciliation and solidarity could not be attained if he did not give up the presidency. The press release was petitioner's valedictory, his final act of farewell. His presidency is now in the past tense. Estrada also argued that the respondent could not have replaced him either in an acting capacity because the determination of the president's inability to discharge the powers and functions of his office should be made by the Congress pursuant to the procedure laid down in Section 11 of Article 7. Whenever the President transmits to the President of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office and until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the Vice President as acting President. Whenever a majority of all the members of the Cabinet transmit to the President of the Senate and to the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office, the Vice President shall immediately assume the powers and duties of the office as acting President. Thereafter, when the President transmits to the President of the Senate and to the Speaker of the House of Representatives his written declaration that no inability exists, he shall reassume the powers and duties of his office. Meanwhile, should the majority of all the members of the Cabinet transmit within 5 days to the President of the Senate and to the Speaker of the House of Representatives the written declaration that the President is unable to discharge the powers and duties of his office, the Congress shall decide the issue. For that purpose, the Congress shall convene, if it is not in session, within 48 hours, in accordance with its rules and without need of call. The Congress, within 10 days after receipt of the last written declaration, or, if not in session, within 12 days after it is required, to assemble determines by a two-thirds vote of both houses voting separately that the President is unable to discharge the powers and duties of his office, the Vice President shall act as President. Otherwise, the President shall continue exercising the powers and duties of his office. Whenever the President transmit to the President of the Senate and the Speaker of the House of Representatives written declaration that he is unable to discharge his powers. The court held that he had not been replaced on that ground in any way. The Senate and the House of Representatives had, by resolution, formally recognized Gloria Macapagal Arroyo as the constitutional successor of Joseph Estrada by reason of his resignation as President of the Philippines. The following additional rules on presidential disability were originally embodied in a statute only but have now been transferred to the Constitution. Section 11. Whenever the President transmits to the President of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office and until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the Vice President as acting President whenever a majority of all the members of the Cabinet transmit to the President of the Senate and to the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office, the Vice President shall immediately assume the powers and duties of the office as acting President. Thereafter, when the President transmits to the President of the Senate and to the Speaker of the House of Representatives his written declaration that no inability exists, he shall reassume the powers and duties of his office. Meanwhile, should a majority of all the members of the Cabinet transmit within 5 days to the President of the Senate and to the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office, the Congress shall decide the issue. For purpose, the Congress shall convene it is not in session within 48 hours in accordance with its rules and without need of a call. If the Congress, within 10 days after receipt of the last written declaration, or if not in session within 12 days after it is required to assemble, determines by two-thirds vote of both houses voting separately that the President is unable to discharge the powers and duties of his office, the President shall act as President. Otherwise, the President shall continue exercising the powers and duties of his office. Section 12. In case of serious illness of the President, the public shall be informed of the state of his health. The members of the Cabinet in charge of national security and foreign relations and the Chief of Staff of the Armed Forces of the Philippines shall not be denied access to the President during such illness. In the event that both the offices of the President and the Vice President are vacated, the following rules shall apply. Section 10. The Congress shall at 10 o'clock in the morning of the third day after the vacancy in the offices of the President and Vice President occurs convene in accordance with its rules without need of a call and without 7 days enact a law calling for a special election to elect a President and a Vice President to be held not earlier than 45 days nor later than 60 days from the time of such call. The bill calling such special election shall be deemed certified under paragraph 2, section 36, article 6 of this Constitution and shall become law upon its approval on the third reading by the Congress. Appropriations for the special elections shall be charged against any current appropriations and shall be exempt from the requirements of paragraph 4, section 25, article 6 of this Constitution. The convening of the Congress cannot be suspended, nor the special election postponed. No special election shall be called if the vacancy occurs within 18 months before the date of the next presidential election. Oath of office. The taking of the Philippine Political Law, Executive Department by Cruz. The taking of the oath of office by the President-elect marks his formal assumption of his duties. The prescribed oath is provided for as follows. Section 5, oath of office. Section 5, before they enter on the execution of their office, the President, the Vice President, or the acting President shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully and assiduously fulfill my duties as the President of the Philippines, preserve and defend its Constitution, execute its laws, do so justice to every man, and consecrate myself to the service of the nation, so help me God. In case of affirmation, last sentence will be omitted. The oath is not a source of substantive power but is merely intended to deepen the sense of responsibility of the President and ensure a more conscientious discharge of his office. Nevertheless, it has been invoked as a justification for presidential action, as when President Quezon sought to mitigate his outburst against a judicial decision which he later found to be still pending appeal. He said he had been moved to speak out because of his sworn duty to do justice to every man. President Lincoln also invoked his oath to execute the laws when he suspended the privilege of the writ of habeas corpus during the American Civil War. That oath, he said, was registered in heaven. Perquisites and inhibitions. Article 7, Section 6 provides for the perquisites of the President and the Vice President as follows. The President shall have an official residence. The salaries of the President and Vice President shall be determined by law and shall not be decreased during their tenure. No increase in said compensation shall take effect until after the expiration of the term of the incumbent during which such increase was approved. They shall not receive during their tenure any other emolument from the government or any other source. The prohibition against the change of their salary, either by reduction or increase during their term, is meant to prevent the legislature from weakening their fortitude by appealing to their avarice or corrupting their integrity by operating on their necessities. The emoluments which they may not receive during their tenure from the government or any other source that is private refers to any compensation received for services rendered or from possession of an office. Emolument has been defined as the profit arising from office or employment, that which is received as compensation for services or which is annexed to the possession of office as salary, fees, and perquisites. Advantage, gain, public or private. The gain, profit, or advantage which is contemplated in the definition or significance of the word emolument as applied to public officers clearly comprehends a gain, profit, or advantage which is pecuniary in character. This means that the President cannot accept other employment elsewhere, whether in the government or the private sector, and must confine himself to the duties of his office, although in the case of the President, Vice President, he may be appointed to the Cabinet. It is submitted, though, that the Vice President may not receive additional compensation in the second capacity because of the absolute prohibition in the following inhibitions are also provided by Section 6. This means that the President cannot accept other employment elsewhere, whether in the government or in the private sector, and must confine himself to the duties of his office, although in the case of the Vice President, he may be appointed to the Cabinet. It is admitted, though, that the Vice President may not receive additional compensation in the second capacity because of the absolute prohibition in the above provision. The following inhibitions are also provided by Section 13. The President, Vice President, the members of the Cabinet, and their deputies or assistants shall not, unless otherwise provided in this Constitution, hold any other office or employment during their tenure. They shall not, during said tenure, directly or indirectly practice any other profession, participate in any business, or be financially interested in any contract with or in any franchise or special privilege granted by the government or any subdivision, agency, or instrumentality thereof, including any government-owned or controlled corporations or their subsidiaries. They shall strictly avoid conflict of interest in the conduct of their office. The spouse and relatives by consanguinity or affinity within the fourth civil degree of the President shall not, during his tenure, be appointed as members of the Constitutional Commission or the office of the Ombudsman, or as secretaries, undersecretaries, chairmen, or heads of bureaus or offices, including government-owned or controlled corporations and their subsidiaries. These inhibitions are in line with the principle that a public office is a public trust and should not be abused for personal advantage. Significantly, except only for the Vice President, who may be appointed to the Cabinet, and the Secretary of Justice, who may be designated as an ex officio member of the Judicial and Bar Council. All the officers mentioned in the above provision are now inhibited from holding any other office or employment in the government during their tenure. This will discontinue the lucrative practice of cabinet members occupying seats in the boards of directors of affluent corporations owned or controlled by the government, from which they derive substantial income in addition to their regular salaries. The second paragraph of the provision, which is new, is intended as a guarantee against nepotism, hitherto prohibited only by statute. In Civil Liberties Union versus the Secretary of the petitioner challenged Executive Order Number 284, which in effect allowed cabinet members, their undersecretaries and assistant secretaries, and other appointed officials of the executive department to hold other positions in the government, albeit subject to the limitations imposed therein. The respondents, in refuting the petitioner's argument that the measure was violative of Article 7, Section 13 of the Constitution, invoked Article 9b, Section 7, allowing the holding of multiple positions by the appointive official if allowed by law or by the primary functions of his position. In declaring the executive order unconstitutional, the court declared through Chief Justice Fernan, in the light of the construction given to Section 13, Article 7 in relation to Section 7, Paragraph 2, Article 9b of the 1987 Constitution, Executive Order Number 284, dated July 23, 1987, is unconstitutional, ostensibly restricting the number of positions that cabinet members, undersecretaries, or assistant secretaries may hold in addition to their primary position to not more than 2 positions in the government and government corporations. Executive Order Number 284 actually allows them to hold multiple offices or employment in direct contravention of the express mandate of Section 13, Article 7 of the Constitution, prohibiting them from doing so unless otherwise provided in the 1987 Constitution itself. The court is alerted by respondents to the impractical consequences that will result from a strict application of the prohibition mandated under Section 13, Article 7 on the operations of the government, considering that cabinet members would be stripped of their offices held in an ex officio capacity by reason of their primary positions by virtue of legislation. As clarified, this decision ex officio posts or those acquired by the primary functions of the executive official concerned do not fall within the definition of any other office within the contemplation of the constitutional prohibition with respect to other offices or employment held by virtue of legislation, including chairmanships or directorships in government-owned or controlled corporations and their subsidiaries. Suffice it to say that the feared impractical consequences are more apparent than real. Being head of an executive department is no mean job. It is more than a full-time job, requiring full attention, specialized knowledge, skills, and expertise. If maximum benefits are to be derived from a department head's ability and expertise, he should be allowed to attend to his duties and responsibilities without the distraction of other governmental offices or employment. He should be precluded from dissipating his efforts, attention, and energy among too many positions of responsibility, which may result in haphazardness and inefficiency. Surely the advantages to be derived from this concentration of attention, knowledge, and expertise, particularly at this stage of our national economic development, far outweigh the benefits, if any, that may be gained from a department head spreading himself too thin and taking in more than what he can handle. The court clarified that the prohibition against holding dual or multiple offices or employment under Section 13, Article 7 must not, however, be construed as applying to posts occupied by the executive officials specified therein without additional compensation in an ex officio capacity as provided by law and as required by the primary functions of said officials of office. The reason is that these posts do not comprise any other office within the contemplation of the constitutional prohibition, but are properly an imposition of additional duties and functions on said officials. In Funa versus Ermita, the petitioner questioned on the basis of Section 13 the constitutionality of the designation of the Undersecretary for Maritime Transport of the Department of Transportation and Communication as officer in charge of the Maritime Industry Authority, Marina. The private respondent Bautista justified her holding of said posts, concurrently invoking the provisions of Section 7, Paragraph 2, Article 9b, which allows the holding by an appointed official of another office if allowed by law or the primary functions of his position. The Supreme Court, in sustaining the challenge, held that Bautista, being then the appointed Undersecretary of DOTC, she was thus covered by the stricter prohibition under Section 13, Article 7, and consequently she cannot invoke the exception provided in Section 7, Paragraph 2, Article 9b, where holding another office is allowed by law or the primary function of the position. Neither was she designated OIC of Marina in ex officio capacity, which is the exception recognized by the Civil Liberties Union. The court emphasized that the 1987 Constitution and prohibiting dual or multiple offices as well as incompatible offices refers to the holding of the office and not to the nature of the appointment or designation, words which were not even found in Section 13, Article 7, nor in Section 7, Paragraph 2, Article 9b. To hold an office means to possess or occupy the same, or to be in possession and administration, which implies nothing less than the actual discharge of the functions and duties of the office. For virtually the same reasons, the Supreme Court likewise nullified in Funa versus Agra the designation of the respondent as acting Secretary of Justice concurrently with his position of acting Solicitor General stressing that it was of no moment that Agra's designation as acting Secretary of Justice was in an acting or temporary capacity. Citing Public Interest Center INC versus Alma, it emphasized that the only two exceptions against the holding of multiple offices are those provided for under the Constitution, such as Section 3, Article 7, authorizing the Vice President to become a member of the Cabinet and 2 posts occupied by executive officials specified in Section 13, Article 7, without additional compensation in ex officio capacities as provided by law and as required by the primary functions of the officials' offices, and that the phrase the members of the cabinet and their deputies or assistants found in Section 13 referred only to the heads of the various executive departments, their undersecretaries and assistant secretaries, and did not extend to other public officials given the rank of secretary, undersecretary, or assistant secretary. On the other hand, in Betoy versus Board of Directors, National Power Corporation, the court upheld the validity of a law providing for the designation by Congress of members of the National Power Board of Directors (NPB). It noted that their designation, which connotes an imposition of additional duties usually by law upon a person already in the public service by virtue of an earlier appointment, and which does not entail payment of additional benefits or grant upon the person so designated the right to claim the salary attached to the position, did not violate the constitutional prohibition, considering that the concerned cabinet secretaries were merely imposed additional duties and their posts in the NPB do not constitute any other office within the contemplation of the constitutional prohibition. It is significant that, consistent with its ruling in the Civil Liberties Union case, the court stressed that the concerned officials under the law to serve as members of the NPB should not receive any additional compensation pursuant to their designation. The second paragraph of Section 13 prohibits the President from appointing his spouse and relatives by consanguinity or affinity within the fourth civil degree as members of the constitutional commissions or the office of the ombudsman, or as secretaries, undersecretaries, chairmen, or heads of bureaus of offices, including government-owned or controlled corporations and their subsidiaries. Obviously, the prohibition applies only during his tenure, as superfluously provided for in this section, as clearly may not exercise his power of appointment after his tenure. Significantly, this provision does not preclude him from appointing his aforesaid relatives to the judiciary. Executive privilege. This special privilege of the President, although not expressly conferred upon him under the Constitution, has been invariably acknowledged as essential to his exercise of his powers as the Chief Executive, consistent with the principle of separation of powers.